Good afternoon.
Good afternoon, Miss Bell. How are you this afternoon?
I'm doing well, Judge. How are you?
Doing well, thank you. I think we're trying to, Mr. Wilder is actually present in the courtroom. I think the court
Okay.
reporter's trying to help him get set up.
Makes it interesting.
And we see you, Donna, now.
Yes, sir.
All
Slide over a little bit.
right, we will, there you go. All right, we'll call number 2023-073, Gregory Anderson, individual and next defendant RA and DA minors versus Desma Anderson. And Mr. Wilder, are you ready as ad-lib on behalf of Mr. Anderson's children?
Yes, sir.
All right, and Ms. Bell?
Yes, Your Honor, present and ready on behalf of Desma Anderson.
All right. All right, Mr. Wilder, if you'll go ahead and call Mr. Anderson. Mr. Anderson, if you'll raise your right hand, please, sir. You do solemnly swear, promise, or affirm the testimony you give in the case pending before the court shall be the truth and the whole truth and nothing but the truth, so help you God.
Good.
All right, and Mr. Anderson, scoot up a little bit closer so we can hear you. All right, you may proceed,
You want me to question him, Judge?
please.
Sir, state your name for the record.
Gregory Charles Anderson.
And Mr. Anderson, you're here today because there was a lawsuit filed in this court wherein you were the next friend and father of the children that are the subject of this suit, Robert and Desai. Is that correct?
Yes,
And the defendant in this case is Desma Anderson. Is that correct?
yes,
And was this an accident that occurred while she was driving a vehicle with the children in the car?
yes,
And did that accident happen on or about September 17th of 2021?
yes,
And was that in Russ County, Texas?
yes,
Now, as a result of that accident, were your children, Robert, Charles Anderson, and Desire Anderson, did they have injuries?
yes,
And we've been working for quite some time to get this case resolved. And we finally kind of got everything to where we could come to court today and get this thing over with, correct?
yes,
Now, we had some issues concerning the medical bills and responsibilities of payment. And we've got all of that whittled down now, and it's been prepared and put in a judgment, which you signed, I signed, and Ms. Bell signed, and it's before the court to be approved. You understand that?
yes,
And the numbers that are within that, sir, have you reviewed all of those concerning the bills and the money that would be received by your children?
yes,
As far as the injuries went with your children, and it's been some time since the accident, in your opinion, have they reached a full recovery?
yes,
They're not continuing to seek any medical care, is that correct?
no,
They seem to be doing okay to you and back to their normal behavior.
yes,
And these kids have been living with you on a continuous basis since they were born, and you're familiar with how they were before the accident and how they are now. Is that correct?
right, yes,
And as far as you can tell, and you've been told by medical staff and professionals, the children have reached a maximum recovery and are not in need of any further care.
yes,
And the children are pretty young, is that correct?
yes,
How old is Robert
4,
and how old is Desire?
9,
You understand, sir, that the settlement that we've reached, since they're minors, this money would go into the registry of the court here in Russ County, Texas.
yes,
And that money would stay there until such time as the children reached 18 years of age and or it was released by some order of the court. Do you understand that?
yes,
And You understand, sir, that this settlement is a full and final settlement, and in fact, you've signed a settlement release and indemnity agreement concerning both children, that you understand that this is a one-time payment made by the company representing Miss Anderson, that there would be no other payments made, and that you would be barred and prevented from here forward of ever filing any sort of claim on this accident for the children against Miss Desmond Anderson. Do you understand that?
Yes.
As far as the bills go, though, again, those are outlined in the judgment, but Robert is receiving an amount of money, $9,400. Do you understand that?
Yes.
Do you understand that he had a UT Health hospital lien of $2,775.40?
Yes.
And do you understand that I've gotten that as the ad litem reduced to $1,000?
Right. Yes.
And as a result of that, the child's going to receive $8,400.
Yes.
And do you think that based on the situation at hand, that amount of money is a fair and just settlement in the best interest of the child at this time to settle the case for that amount of money?
Yes.
And Judge, I have, which I would show to the court, a copy which I've marked as ad litem for plaintiff's number 1, which is a settlement reduction from Revocor, which represents UT Health. And I'd offer that as Exhibit 1, which shows the settlement amount that was reduced down for Robert Charles Anderson.
Any objection, Ms. Bell?
No objection, Your Honor.
It will be received.
Like, as far as Desire Anderson, she had a little different situation. Is that correct?
Yes.
Her injuries were a little more extensive. Is that correct?
Yes.
And she had a UT Health hospital bill of $71,351.21. Is that your agreement? That's what her bill was.
Yes.
Okay. You understand that there's a $30,000 limit on the policy. Do you understand that?
Right.
And the hospital could not take more than half of that, which would be $15,000. You understand that? Do you understand that I've negotiated with the hospital to reduce that down to $10,000? And there's also a small Medicaid lien of $1,512.24. And after those two numbers are taken out, it would leave the child Desire $18,487.76. Do you understand that?
Yes.
And based on the situation and the funds available, do you think that that's a fair and just settlement amount, and ask the court to approve that?
Yes.
And Judge, again, I'm going to sponsor what's been marked as ad litem for the plaintiff, Exhibit number 2, which is a document again from Revocor, which illustrates the balance that was owed to UT Health Tyler and the settlement amount which they've agreed to take of $10,000. I would offer that as Exhibit 2.
Any objections, Ms. Bell?
No objection, Your Honor.
It'll be received. Mr. Wilder, just make sure the court reporter gets both those documents.
Yes, sir. Now, Mr. Anderson, you understand there were some other bills involved, but there were no liens, et cetera. Those would be the responsibility of you and your wife as a parent of the child. Do you understand that?
Yes.
Okay. Are you asking the court to approve this settlement as a fair and just settlement for the purposes of your 2 children and the injuries they received in this automobile accident?
Yes.
And you have some documentation that I've given you from the clerk here that you'll need to fill out and return to them. And I've explained to you at such time as that's done, then Miss Bell and her staff, have the checks that they will forward to the Russ County clerk to deposit and invest for the benefit of your children.
Yes.
And you understand that, that responsibility is on you to get that up here and get it back to the district clerk.
Yes.
Is there anything else, sir, that you want, to address that I haven't asked?
No.
Good. Pass the witness.
Ms. Bell.
Your Mr. Wilder did such a thorough job. I just have a few follow-up questions. Good afternoon, Mr. Anderson.
Good afternoon.
Mr. Anderson, you understand that you had a right to a jury trial in this matter?
Yes.
And you understand that if you went to trial, that you could have received more money, less money, or nothing at all at trial?
Yes.
Okay. And you understand you've waived your right to a jury trial?
Yes.
And that's because you believe that the settlement is in the best interest of your minor children.
Yes.
And Mr. Anderson, based on what Mr. Wilder's discussed and what we've discussed just now, are you asking the court to approve the settlement as being fair, reasonable, and in your minor children's best interest?
Yes.
Thank you. No further questions. I pass the witness.
All
And Judge, I represent to the court, that I've reached an agreement with Miss Bell and her staff, for purposes of my ad litem fee. And that's outlined in the judgment.
right.
Ask the court to approve that.
All right. And I'll ask for your recommendation, Mr. Wilder, concerning the settlement.
Judge, I would, ask that the court, follow the proposal in the final judgment. I don't believe there, since this was the mother of the children that was driving the vehicle, and as far as any asset, et cetera, that might have been available to pursue outside of the insurance, I don't believe there was any. The insurance was limited, and based on the available insurance and the injuries and the status of the children, I think it would be in the best interest for the court to approve the settlement.
All right. Based on the testimony before the court finds that the proposed settlement is set forth in the final judgment is just, fair, and equitable. And as far as the apportionments concerning the payment of the bills with the remaining, the court will order that for DA, a minor, that the total of $30,000 with $9,000 to be set out or put into the registry of the court, and for R, make sure I'm getting the names right. That was for R. RA.
That was for RA.
RA judge will get $8,400.
And yeah, $8,400 to be deposited into the registry of the court, and then for DA, $18,477.76 to be deposited into the registry of the court after payment of the bills in this matter. And the court approves the ad litem fee. For some reason, the court has already signed the final judgment in this matter on December 3rd. So to accurately reflect what we have done here, if y'all would just present, trying to figure out the best way to do this. Since everybody, I know that y'all have had a hard time getting this done, I'm gonna order that be pronounced as an amended judgment, and with the accurate date of today's, and the court, in other words, it's already in the file and it says December the 3rd and was signed by the court inadvertently and filed on that day. I'm going to have the clerk's office pull that copy out while Mr. Anderson is here so he can initial, and I'll make a copy of a new judgment. I'll make a copy of this judgment and just put today's date in there with the signatures, with the understanding that these signatures already on there and I'll get Mr. Anderson and Mr. Wilder to initial, and Miss Bell it's the same judgment. Miss Bell, I'll just put my initials by your name if that's okay.
That's fine, Your Honor.
Okay.
Yes, you have my permission to do that
All we're doing is just changing the date from the 3rd until today's date.
today.
To accurate reflect what we've done here today. You understand that, Mr. Anderson?
Yes, sir.
Okay, all right. Anybody have any objection to doing that? All
No,
right.
sir.
No objection, Your Honor.
All right, very good. All right, thank y'all so much for your cooperation in this matter, and we'll stand in recess.
Thank you,
Thank
Judge.
you, Your Honor.
Thank you, Smell.
Wilder, y'all
Thank
just,
you.
thank you, Miss Bell. If y'all would just
Thank you, Your Honor.
cross to the clerk's office, we'll take care of that.
Yes, sir.
All right, thank you.
Okay.